There you go.
Okay, well, we're somewhat of an abridged crew, but hopefully those that had issues getting onto the webinar will be able to view this offline later. So first, welcome, good morning. My name is Dror Futter. I'm a partner at the Rimon PC law firm. The array of buildings on the slide in front of you is because Rimon is a virtual law firm in the sense that we don't have offices, and our attorneys are scattered in about 35 locations in more than a dozen countries. And these are major buildings in each of the locations where we have attorneys. I'm speaking to you from northern New Jersey. We don't really have a signature building in North Jersey. So next to the Empire State Building, I think is a Goldman Sachs building in either Jersey City or Hoboken, which is about as close as we get. We could put a slide, and our full slide actually has a picture of the Statue of Liberty, but I think New Jersey only has about a third of the island, and it's not the part with the statue. Okay, my practice basically focuses on representing startups, both in terms of their corporate and financing needs, as well as their commercial transactions. Before going back to private practice, I was the general counsel of a startup, and before that, I was the general counsel of a venture capital firm. So I've kind of seen the ecosystem on all sides. In addition, I started giving a presentation with this title probably about 6 or 7 years ago, and I actually revamped it for today's presentation. So you guys will be, in a sense, the guinea pigs. But one of the reasons why I revamped it is I think some of my conclusions are much firmer after being back in private practice for 6 or 7 years. Some of the problems just seem to come up every single time, and I wanted to touch those issues and give pretty decisive and practical guidance on those points. Now, this being a legal presentation, you kind of had to know this was coming. What I say today is not the views of Rimon. For all I know, it might not even be my own views. If you have a legal problem, see a lawyer. This will be basically a discussion of general practical principles of law.
Right there.
So the first thing your startup attorney should tell you is, if you're a founder, I don't represent you. I represent the company. Now, when a startup is 3 people in a garage, most of the time it's kind of hard to separate the 3 people from the company, but inevitably conflicts of interest will arise. And as the attorney, my client is the company. And I, from an ethical perspective, have to service the best interests of the company as I see them. And particularly with early stage companies, 90+% of the time, it's not going to make a difference. The interests of the company are the interests of the founders and vice versa. But in those other 10 or so % of the time, maybe a little bit less, issues arise, and I'm advising the company. And the founders either have to take their own self-counsel or they have to engage their own counsel.
Can I ask you a question? When you say the company, do you mean the shareholders?
So that's an interesting question of what is the company. So yes, nominally, the company is the interest of the shareholders. And at that point in time, the founders generally are the shareholders. So that's why there's generally alignment. But you then come across cases, somebody's underperforming, somebody does something without authorization, where suddenly the founders and the company are not one and the same. And that's where it has to be very clear, that I'm not representing the company. Or even in terms of how you structure your governance, and what I advise the company for the smooth functioning of the company may not be the ideal thing for you as the founder. And so when there are conflict situations like that, one, I have an obligation to tell you, I'm representing the company here, and this may not necessarily be in your interest. But at the end of the day, I have to do what is best kind of for the company on a holistic basis. And that is not always 100% clear when the founders are the shareholders and vice versa. It becomes much clearer once there are non-founder shareholders in the company. But those divergences can start early. And, there is, we'll get to it in a couple of slides. I wouldn't say it's the norm, but there is a very high percentage, particularly when there are more than two founders, of kind of founder fallout scenarios. And so inevitably, we're going to be dealing with one founder who's on the out with the other founders. And at that point, I'm Switzerland. I have to represent the company. So what will happen is, and let's say what I will often do is tell clients, listen, I'm not representing you in this negotiation. Your interest and the company's interests are not aligned here. If it's important enough to you, seek counsel. And in general, you don't want a lot of lawyers hovering around an early stage company. So most of the time they take their own counsel. But from my perspective, it's important that I let them know that they're kind of on their own from a legal counseling perspective. Fortunately, these instances are rare early on, but inevitably they will crop up. The hope is that it'll crop up when you have other non-founder shareholders, and then the interest of the company versus the interest of the founders the delineation will become much clearer. Also, while we're talking about the subject of attorneys, I'll just say a word about attorney-client privilege. If there is, heaven forbid, litigation involving your company, every litigation has a phase called discovery, where the other side gets to ask for all your documents, communications, electronic files, print files, a whole host of data. To promote candid conversation between attorneys and their clients, there's a thing called the attorney-client privilege. And documents that qualify for this privilege don't get produced as part of a litigation. This is a kind of poorly understood concept, but in general, it's one that you really should limit to point-to-point conversations between you and your attorney. So don't CC the entire world, don't forward your attorney's communication to third parties. There are lots of ways you can blow the privilege, and this could be the subject of a fascinating webinar, or maybe not so fascinating webinar, all of its own. But the long short of it is, without doing a deep dive, if you have a sensitive communication with your attorney, limit it to a direct one-on-one communication. Don't forward it. Don't CC a lot of other players. Okay, this is the slide that has changed the most dramatically in the 7 or 8 years that I've been back in law firm practice. When I started going back to when I left my in-house position, I was agnostic on an LLC versus a C corporation. To give you a sense of where I've gone on this issue, a few months ago, I posted on LinkedIn that friends don't let founder friends form LLCs. Now, so why would somebody consider forming an LLC? Two basic reasons are given. There are some secondary issues, but the two main reasons are: one, the LLC structure avoids the double tax, and number two, that an LLC is less expensive to form. So let's unpack both of these, and we'll do it in reverse order. So number one, in terms of expense, yes, in a very narrow sense, it is generally cheaper to form an LLC. We're not talking about a dramatic difference. It's a difference measurable in hundreds of dollars. Over the lifespan of the company, it will be significantly more expensive to maintain it as an LLC. And the main reason for this is corporate structure is in the venture space is pretty, the playing field is pretty rigorously defined, but there isn't a lot of optionality in terms of how it's structured. So everybody's forms look plus minus the same. It's easy to see where things are changed. There is a universe of LLC operating agreements. Operating agreements are the LLC equivalent of a certificate of incorporation and bylaws. And every one kind of requires custom review, custom modification. So over the lifespan of an LLC, any initial cost savings is you know, is diminished and exceeded by the additional cost. And the reality is, if you're going to seek venture funding for a number of reasons, investors at some point will likely require you to convert to a C corporation. And so this is basically adding a step to the process in return for some nominal cost savings up front. Number two is the double tax. So the LLC is what's known from a tax perspective as a pass-through entity. LLCs don't pay tax. They divide up profits or losses and allocate them to the members of the LLC. And then the members of the LLC get K1s, and they pay taxes or take losses based on what the LLC reports. In a C corporation, when you have profits, the C corp pays corporate tax, and then if it dividends what's left to the shareholders, there's a tax on the dividends. So that's the dreaded double tax. Good news, not a lot of startups suffer from the problem of having profits. So at the end of the day, the double tax won't kick in as a practical matter for several years. And by that point, if you're venture successful and you're continuing to fundraise, the odds are very strong that you will have been required to convert to a C corporation. So there's a lot of quasi-mythology around why you should pick an LLC. Technically, both points are correct. As a practical matter, there's no reason to do it. It just adds a step. And it makes, and there are some things that are, that if you're going to eventually transition from an LLC to a C Corp, actually become more difficult as a result of the transition. So for example, in a C Corp, employees are granted options. In an LLC, there's a rough equivalent, which conceptually and economically function almost the same way, called profits interests. The problem is, if I start an LLC, grant profits interests, and convert the company to a C Corp, there is no tax efficient way of doing that transition. And if I'm going to duplicate the economics to the employees, there is going to be some tax inefficiency along the way that either the employee or the company would have to bear. And the bottom line, and having now done a bunch of these, there are so few cases where it makes real sense to start life as an LLC. Why Delaware? So there are a couple of points here. One, Delaware has a really well-developed body of corporate law. It's actually interesting. I've been practicing in New Jersey most of my career. Only in the last 2 years have I encountered a couple of New Jersey entities. Most venture entities, as I say, get formed in Delaware, based on Delaware law. If your company's operating in either New York or California, you might see incorporation in those states. But outside of those three states, occasionally Massachusetts, occasionally Illinois, occasionally Texas, most of your incorporations are going to be in Delaware. And Delaware has a really well-developed body of corporate law. So, in one of those cases that I had with a New Jersey corporation, there actually was a board dispute. And I had to look up what New Jersey law says about the dispute. And ironically enough, the court basically in its decision said, New Jersey's never addressed this issue. We're going to look to see what Delaware does. So Delaware is just a more robust corporate form. Second, the industry forms, which are put out and maintained by the National Venture Capital Association, are based on Delaware law. That doesn't mean you can't adopt them under other state laws, but they are optimized to work under Delaware law. And third, there's just a fair amount of inertia within the industry. Everybody's kind of familiar with these forms, familiar with Delaware law. And so it's not impossible to move it off. But in general, the industry tends to work around Delaware entities. Footnote, when you set up your Delaware corporation, you still need to qualify to do business in whatever state or states you're quote doing business. What constitutes doing business, particularly in the age of work for home, is becoming somewhat of a tricky call. But at least at a minimum, if you incorporate in Delaware, but your offices are in New Jersey or New York, you should be qualifying if they're your main offices in whatever state the offices are. And so almost simultaneously with your formation, your next step should be to qualify them in the state or states where you're considered doing business, and your counsel can advise you which states would be required. Okay, so do you know who owns part of your company? Or in other words, do you know who your shareholders are? This is really an area which can be very embarrassing because when you go to investors, they're going to ask you who your shareholders are. And they're going to ask you to generate a document called the cap table, which shows all the people with equity rights in your company. And it is somewhat shocking that a lot of times there are people or entities that are missing. You had an early employee, you told them, I'll give you 3% of the company. You forgot about it. That person sure didn't forget about it. There may be some email traffic. There certainly wasn't an agreement. And then suddenly after you announce a large financing, or even worse, you announce that you're being acquired, that person emerges from the woodwork with their email and suddenly you have another shareholder that nobody's ever heard of. So point number one, make sure all equity grants or acquisitions are properly documented, and also that they've been properly authorized by the board of the company, and then if your documents require the shareholders as well. Never do this as an informal thing. Your aunt Zadie wants to give you some money, document it. You want to be able to have a paper trail on every dollar that comes into the company. You don't want to have disputes later on. Was this money considered a loan? Was this money considered equity? There are tax consequences to how the money came in, both for the company and for the person giving you the money. This is not something, no matter how early it is, that should ever be done kind of verbally or even informally. You have to be particularly careful around employee equity grants because they are considered compensation. If you do them improperly, you may be generating income for the current income for the employee that has tax consequences, and there might be consequences to the company. For example, if the company issues options that are in the money at the time of issuance, that creates an issue under 409A of the tax code, which is a deferred compensation section of the code, and can create liability for the company. So particular sensitivity around employee equity grants, but in general, this is not, there's a lot of DIY lawyering in the early stage. When money's coming in, you want to make sure it's done right, because the last thing you want are people coming up with claims that are poorly documented and as a result unclear. So every so often I'll get a call for an early stage investor who wants founder's equity. And I kind of chuckle because as my grandmother used to say, founder's equity is not such a bargain. There's really nothing great about founder's equity. Its greatness comes in the sheer number of shares the founders own rather than the attributes of the shares. Now, the contrast is investors, and investors generally get preferred shares. And the preferred shares come with a basket full of goodies in terms of enhanced rights that the investors get. So they will get a liquidation preference, which means that the company isn't successful. They get as much of what's left as possible to recoup their investment. They might get voting control rights, a board seat, possibly a dividend. There's a whole package of rights that comes with being an investor. But in general, for early stage founders, you are dealing in common shares. For really kind of serial entrepreneur founders, There's sometimes a founder's class of shares that's created with some special rights. That's not likely to be the case with your first startup, and it's even rare subsequent. So there are some exceptions to that, but in general, when we're talking about founder shares, we're talking about common shares that are owned by the founders, that are owned by the employees, and often some of the early angel investors in the company. Okay, you and your co-founders need an agreement like yesterday. And the reason for this is, the analogy to a prenup is unfortunate but pretty strong. When founders come together to form a company, it's kind of the era of good feeling, and everybody's getting along and everybody's working hard, and you can't even see a day when you would have a disagreement. On a statistical basis, it's pretty certain for the majority of companies that there are going to be disputes between founders. In the best case, they'll get resolved quickly and without too much damage. And every startup attorney has their nightmare stories of founder disputes that have gone crazy. And one of the things that serves as igniter fuel for disputes that go crazy is the absence of an agreement between them. So you want to have an agreement that kind of covers a few major points, and you can document it in several ways and introduce it in several different ways. But the critical thing is that you address at least these 4 scenarios. 1, how is control of the company going to work? How is decision-making going to work? 2, how are economics going to be divided? Not every person who is there on day 1 is really a founder. Founders are kind of long-term players who will get the company at least way down the road, preferably to an exit, but if not, to a pretty advanced stage of development. The person who's doing kind of front-end web development for you on day 1 might be part of the founding team, but they are not a founder, and they shouldn't be getting the economics of a founder. And this is a problem because everybody's feeling good and everybody's teaming and working hard, and it kind of disrupts that spirit. But you have to be realistic and make sure that the economics of the shareholdings and compensation match the contributions, and more critically, the long-term prospects of that person in the company. Responsibilities, who's going to manage what parts of the company, what decisions can be made independently, what decisions have to be brought back to other founders, and you have to document kind of an approval threshold that needs escalation. And then departure termination scenarios. Things didn't work out, somebody got a better opportunity. There is a very high rate of founder dropouts in early stage companies. You want to make sure that the economic principles of what will happen at that point are well defined. Will the person retain any equity? Will they lose all their equity? What else will you need from them on departure? And this can kind of be divided into different categories: departure for cause, departure at the founders, whim. I mean, there are different scenarios, so it's not like there has to be one set consequence for a departure or termination. But the rules of the road should be set up, because when you have a team of, let's say, 4 founders, 3 of whom are working 24/7, the 4th kind of falls out, rarely shows up to the office, you have to get rid of the person. And if there isn't an agreement setting out what's going to happen, the only thing you've pretty much assured yourself is a dispute. Okay, this is a major early stage venture problem. Now, the statement that I have here is not 100% accurate. So when I say you can't hire an individual as a contractor, to be fair, I should say almost never. So what's the issue? Basically, it goes under 2 names: either employee misclassification or deemed employment. And the principle is, if it walks like a duck and it squawks like a duck, it's an employee. So you can call the person a contractor. You can give them a contractor agreement. If you're paying them under their Social Security number with a 10, on a 1099 basis, you are likely violating the law. And state and federal authorities have been increasingly cracking down on this problem. And it can result both in requirements to pay back taxes as well as fines. And there was recently a reported case where it resulted actually under personal liability for the directors under an unfair wage practice set of laws. So this is serious stuff, and a lot of ventures trip up on this. And the sad reality is, just like with the LLC, part of the problem here is mythology. The mythology is that a contractor is easier to terminate than an employee. If done right, at least in the United States, that is just not true. Most states in the United States are what are called employment at will states, which means that unless you have a company policy or you promise the employee otherwise, you can fire them at any point in time. There are sometimes issues, sometimes there are discrimination cases, but as a general matter, if done right, you can fire an employee as readily as you can a contractor. There's another mythology that employees have to get benefits. That's a more complicated subject, but the short answer is not in all cases. And there's also mythology on when this doesn't apply. So, if the person works less than X hours, they can be a contractor. Or if the person's only working for 3 months, they can be a contractor. And there are all these rules of thumb that arose because the first major case in this area involved Microsoft in the late 90s. And so in response, there were all these kinds of rules of thumb that people came up with that have pretty much universally been rejected. So if somebody's working 20 hours a week, they're a part-time employee. They're not a contractor. If they're only going to be working for 3 months, they're a short-term employee. And if you know they're only going to be working for 3 months, there's some language I would add to their offer letter. With startups, you generally don't have employment agreements, you have offer letters, and then you have an agreement that covers confidentiality, IP rights, sometimes non-solicitation, non-compete. So you don't have a formal employment agreement, but in their offer letter, if you know they're only going to be employed for 3 months, I would address that fact. It might save some issues down the road. But again, if you hire somebody for 3 months' work, that they are a short-term employee. In almost all cases, they are not going to legally be considered a contractor. And another one, which candidly a lot of ventures breach, unless the individual is getting academic credit for their internship, it is really, really hard to hire an unpaid intern, bordering on impossible. This became a major problem with the 2008 recession. And Condé Nast actually was the subject of the defining case. There has been less of that in the current environment just because of labor shortages, but ventures still find their way to a lot of students, for whom the work will look good on their resume. And unpaid internships are a big problem. The issue is minimum wage laws, which now in a lot of places is rising, into the mid-teens. You really can't avoid paying minimum wage in most cases. Which brings me to our next slide, which is you can't pay for everything you can't afford with equity. So early on, there's this tendency to, I'm cash strapped. What do I have of value? Oh, I can give people, pieces of my equity. Now, I'll put aside kind of the question of what that signals to future investors, that that you value your equity so little that you would kind of give it away for services, and then weeks later, months later, turn around and go to investors and ask them for a much higher valuation of the stock. But the reality is, minimum wage laws, when you give somebody stock, it doesn't count as wages for purposes of minimum wage laws. You still have to pay them minimum wages. And I've seen cases just in the last year of companies that gave wages instead of stock instead of wages to early stage employees. Those employees were terminated, And sure enough, part of the lawyer's letter was a claim for unpaid wages because they hadn't received minimum wages. There are a handful of exceptions. If an individual owns more than 20% of the stock in the company, they don't have to get minimum wages. And in some states, senior members of the executive team can also be paid in stock only, even if they're under the 20% threshold. But as a general rule, you can't substitute stock for minimum wage. The other thing is there are tax consequences to granting equity. Equity has a value. For stock option grants, you actually do appraisals to figure out what that value is. But if you pay a contractor or supplier in equity, right, that should be reported as income to them, and they should be paying taxes on it. And they may not be that thrilled. It's one thing when you're giving somebody free equity, but if they're getting a tax liability on stock that may not have cash value for many years, they may feel very differently about it. And again, this is another area of kind of unforced errors by a lot of startup companies. Okay, handshakes are really wonderful until things hit the fan. And then you will really regret that there isn't documentation around your agreements and understandings. And then you start coming up with a patchwork of communications, these days mostly email communications, to try to demonstrate what the agreement was. Now, agreements don't have to be 48 pages, single-spaced documents. Anything that kind of shows the exchange that's contemplated in the agreement is enough in most cases to have a court determine that an agreement existed. So POs, letters of intent, MOUs, unless they're expressly made a non-binding, in order acknowledgement with terms and conditions, click wraps, shrink wraps. But I can't stress this enough, because the need not just to document, but to do so contemporaneously. As time passes, memories dim, and trying to go back and document something that happened a while ago is often quite difficult and can lead to further misunderstandings. And also some things you can't go back on. So for example, I was mentioning before, employee equity grants are very, very sensitive from a tax perspective. I had a potential client, spoiler alert, I didn't get the client because I had to give them the following advice. They had promised an employee equity a year ago, never documented it, never submitted it to the board for approval, and now they were getting around to it. Problem was, they had the unfortunate problem that the company had been hugely successful in the year between the time they intended to give the grant and they verbally promised the grant and the time they were actually getting around to do it. And you can't backdate option grants. People have gone to jail for that. So I had to tell them, we can do an option grant on today's price. I can't do anything for you on last year's price. And as a result, you may want to consider giving the employee more shares, more options, because the strike price is going to be higher. They weren't happy to hear that. And I don't think they would have gotten different advice elsewhere, but it highlights the need to be both contemporaneous and clear in terms of documentation. And one other thing, silence is not golden when it comes to contracts. So if I have a PO and I say, I'm going to buy 12 number 2 pencils from you for $1 each, that's a contract. It has price, it has the product or service to be delivered. That's enough from a legal perspective to be called an agreement and to be enforceable. Now the question then becomes, suppose the pencil's defective or it's the wrong pencil. What are my remedies as the pencil buyer? And the law for products, it's called the Uniform Commercial Code. For services, there are what's called common law principles, will actually fill in the legal concepts you didn't address. So for example, when I sell you your pencil, unless we come up with our own warranty that we agree to, I'm basically warranting to you that it's fit for writing. And so a lot of people are unaware that even, they say, oh, we're going to keep it simple, we're going to do a one-pager. That's great. I love simplicity, but understand that sitting behind that agreement is a bunch of things the law is going to imply on your relationship. and you may not be thrilled with all of them. So while, trust me, I've represented more than one startup that's gotten the dreaded 70-page agreement. At least some of that heft is to address issues that the law would decide for you if you didn't have those provisions.
Dror, can I ask a question? What about emails as proof of an agreement?
So the courts generally try to find evidence of a meeting of the minds. So the fact that it doesn't say agreement on it, right? So if I send you an email and say, I'm willing to ship you a dozen pencils, $1 each, and you send me an email that says, ship it,
Right.
Very high likelihood the court is going to view that as an enforceable agreement.
Okay.
Because we have documentation of an offer. I gave you an offer of the terms of service, and you
I accept it.
You accepted it. It could even be simpler than that, right? You could send me an email saying, ship me 12 pencils at $1 each. I ship you the pencils.
Right.
That will be an agreement too, because acceptance doesn't have to be like by a signature. I could actually take actions that constitute acceptance. So contract formation, courts struggle to find the contract formation. They then try to figure out what was exactly agreed to. So you're kind of, the two concepts you're playing with is kind of the minimum amount of information that's critical, right? Does the communication trail include all the critical terms, right? And then, so do we have an agreed vision of what it is? And do we have a situation where it's clear that at some point in that chain, there was an agreed vision of those terms, and then both sides accepted it? And those can be very messy fact-based litigations. But yes, it doesn't have to be something that has 4 whereas clauses to be a valid agreement.
Thanks.
Okay. Your NDA likely won't save you. Do not over rely on your NDAs. At the end of the day, like any contract, it's a ticket to a courtroom. Because if everybody's agreeing and everyone's doing what they're supposed to do, the agreement, the NDA is going to stay in a drawer. And so if you have to take the NDA out and enforce it, you're running into an expensive process. And even if you win the case, you've probably lost on a business level. So NDAs are nice to have. They're essential to have, for example, for maintaining trade secrets, that you document that you took those steps, to keep the protection that comes with trade secrets. But don't start blabbering at the mouth all because you have an NDA in place. It's not pixie dust. Pick your partners carefully. Find out what their reputations are. So, for example, most VCs, at least for most of their initial work, won't sign NDAs. And the reason is because they often look at multiple investments in the same space. And if I, as a VC, talk to your company tomorrow and then talk to one of your competitors a month from now and end up investing in them and not you, I don't want to have a lawsuit where you suggest that I did that because of confidential information I got from you. So most VCs won't, until they're pretty deep and diligent, sometimes not even then, sign NDAs. So option 1, never talk to a VC. Option number 2, deal with VCs that have solid long-term reputations and track records, because they have reputational risk. I mean, the VC world has gotten quite large, but it's still in some ways a small community. And stealing IP from potential investments is not a great way, and getting that reputation is not a great way to get meetings with future potential investments. And then, you don't have to say everything all at once. So you can tier disclosures so that you share kind of low-level sensitive information first and save kind of the secret sauce until the relationship is deepened. And in fact, in some cases, you might not even share it with the third party at all, but you might pick another party to do the evaluation work. So I did some work for a company that Microsoft acquired. They don't want to be tainted by accusations that they stole your IP. So my client, the company that was acquired by Microsoft, submitted its code to a third-party evaluation service that then wrote up a report to Microsoft about the quality of the software without giving away any of the proprietary information of the software. It gave an appraisal of the software, but then Microsoft never received any of the confidential code, which is kind of a win all around from our perspective. It addressed our concerns over sharing our main asset with Microsoft. From a Microsoft perspective, it prevented us from claiming that they had stolen the software if we'd given it to them to review. And then sometimes you'll just limit who at the receiving party is allowed to see the software. And this can either be, kind of generic disclosure on a need-to-know basis. Sometimes if it's really sensitive stuff, you'll basically say, you've got to give me a list in advance of any person who's going to see it. And if you want to broaden the circle, you've got to keep that list updated. Okay. Trademarks are kind of an overlooked area in company formation. And the problem is there are lots of ways that trademarks can infringe other trademarks. Trademarks can infringe other trademarks if they look like the other trademark, if they sound like the other trademark, or they have the same meaning as the other trademark. So for example, a foreign language equivalent could, even though they sound completely different, could be trademark infringement. And the issue is that even if you go to the Patent Trademark Office's database and search for your trademark, that's only going to pull up pretty identical marks, but you can have confusingly similar marks, which is the relevant standard for trademark infringement, that aren't direct hits. And similarly, trademarks don't have to be registered. There are what are called common law trademarks. And if they were there first, they have superior rights in the geographies where the marks were used. So this isn't a day one activity, but before you really put any serious dollars behind a branding campaign, do a trademark search. Usually the search has two components. There's a kind of a quick search, a few $100 to knock out and make sure there aren't any obvious hits. And then a full search, which costs maybe $1,000 or so with attorney review, maybe a bit more. You'll get back from the search firms a report that's about for a good mark where you don't have a problem. It's going to be 100 pages long. The attorney will look through and mostly dismiss anything, but they really go through a lot of different databases to come up with marks that have potentially superior rights. And today's free tip, where a registered trademark is symbolized by an R in a circle. However, a common law trademark, an unregistered trademark, is symbolized by a TM, and you can put a TM on your trademark today without talking to an attorney, without filing anything. And what that does is two things. One, it signals to outsiders that you are reserving rights in the trademark. Two, it suggests to outsiders that you've been talking to an attorney because you know to do this. So it's free and an easy way to do some IP messaging. Okay, we are running out of time. I will briefly touch on patents. Not every great idea is patentable. There are really a lot of problems these days getting software and business method patents. There are certain major decisions that kind of restricted the parameters of that. This is definitely one area of law that you don't want to do at home without mom and dad. There's also a time factor here because the US is a first to file system. So it's kind of a race to the patent office. And there are also timetables that if you don't file within a year of public disclosure, you may be precluded from filing. Fortunately, there is a process in place, which is, it's no longer new, but it's relatively recent addition to the patent arsenal of a provisional patent application, which in theory you could file yourself without a patent attorney. I wouldn't recommend it, but it generally doesn't cost more than a few $1,000s. And it basically gives you a 1-year period to continue to develop your technology and see if it really has value in the market. And only then do you file the full application, which can be considerably more expensive. But you get priority and protection back to the date of the initial filing. One other point on IP generally, make sure that anyone who contributes IP to your company in any form, whether it's your product, whether it's the marketing, really in any shape or form, has either in their as their part of their employment package, or if it's a contractor in their contracting agreement, language that assigns IP rights to you, to the company. This will be part of diligence. I had a transaction where this wasn't fully buttoned up, and we literally had to send somebody to the Ukraine to hunt down a programmer who had worked on the software early in the project, and closing was delayed 2 weeks because of it. And I couldn't really fault the buyer, because from their perspective, they were buying the software, and they needed to know that that Ukrainian programmer didn't have any rights in the software. Okay. Bonus point. So this was a top 10 list. Here's the bonus. So everything we've been talking now are kind of good company building scenarios, but the reality is a lot of ventures fail. And the key there is you cannot run, your runway is shorter than you think. You can't run the bank account down to zero, even if you're going to file a bankruptcy. Bankruptcy will not help you with unpaid wages, and it will not help you with unpaid taxes. And if that's not a scary enough prospect, it's also a scenario where in extreme cases, it could result in personal liability for officers and directors for failing to set aside those funds. So if you're in the unfortunate scenario of a venture that's kind of winding down, keep an eye on the gas tank, figure out what those numbers, taxes, and unpaid wages are going to look like, and make sure you never cross that line. And you can't, for example, for the same minimum wage issues we discussed before, ask employees to come in on a quote volunteer basis, or unilaterally reduce their wages. Now, in theory, you could get them to agree to reduce their wages to minimum wage, but that has to be a consented transaction. That's not something you can unilaterally impose. And you can't have a situation where an employee is showing up for work without your ability to pay them for that day's work. And that is a potential major pothole people don't like to talk about. It's the downside to all the fun things we like to talk about in the venture industry. But reality is probably at least half of early stage ventures fail within 5 years. So a large number of ventures are going to encounter this scenario at some point. Kind of got off to a bit of a late start. I'm happy to stay for a few more minutes if there are any questions. I have some additional resources here. The book that I recommend on a lot of these topics is Venture Deals, Be Smarter Than Your Lawyer, a Venture Capitalist by Brad Feld and Jason Mendelson. That's not a very high standard, but it's a very entertaining book. There are a couple of other sites for the documents that are kind of the key, the staple to the venture industry. And then I've created an article which has links to a series of articles that I've written over the last few years in the venture space at the end of the list. And if you have any questions, my email is on this final slide, and feel free to ping me. Okay, Brenda, thank you very much for and thank you, Kendall, for hosting this.
No worries. Does anyone have any questions?
Thank you, Dror.
Yeah, this was great. Thanks very much, everybody.
Thank you, Dror. If anything, you guys have Dror's email. You can contact Dror. I'll be sending this recording to all the attendees. Thank you, Dror, for joining us today.
Well, happy Hanukkah to those that are celebrating, and happy holidays to everyone who still has holidays to come. Take care.
Bye.